各位委員。
Now we are resuming the meeting. We now come to the final item of agenda, that is the Law Reform Commission of Hong Kong's consultation paper on miscellaneous sexual offences. First, we invite the deputations to join us, and we also invite the representative of the LRC, and the document is CB bracket 4 1109 slash 17 to 18 bracket 02, and the relevant background brief prepared by the Legislative Secretariat. We have 4 deputations today. Four reputations have registered to come to the meeting. If they are here, we will invite them in, and we welcome the LRC representatives. First, I'd like to explain to you, if need to, you can use the headset, and you can also choose the channel for the language. And when you speak, please try not to use both English and Chinese. That may cause difficulty for interpretation. And please note there is an information sheet on your table, especially those in the gallery who can obtain the information from our staff. What you say and submit will not be protected by the Electoral Powers and Privileges Ordinance. Those who have not provided written representations can provide those after the meeting. Now, if we just received it, we may not be able to print it in time. First, we invite the LRC representative to walk us through the document, and then we will ask the bar association representatives to speak. Please do not speak for longer than 10 minutes, and then we will invite the deputations to speak. We hope that each deputation or representative will not speak for more than three minutes. First, I will invite the LRC to speak. We hope to hear more views today rather than to express views ourselves. Mr. Eric Cheung. We will be very glad to hear the public's views. So my introduction will be brief because you probably read our document. Now, this involves miscellaneous offences. That is, now this is the third consultation document on substantive reforms. The first was about rape and sexual crimes, and the second one focuses on protection of children and mentally impaired persons, the reforms thereof, and this time we are focusing on miscellaneous offences, sexual offences. Now, of course, we also have reports on other reforms. Now, after this consultation document, there will be a 3-month consultation period till August 15th, and then we will collate the opinions, and then we will issue a report to cover the 3 consultations. Now, on the miscellaneous sexual offences, there are different areas because they are miscellaneous. The first is about incest, and there is the offense of incest. Now we will suggest that we will keep this offense, but there will be some proposals or recommendations, and we think it should cover uncles, aunties, and other close relatives. On some other issues, we hope to hear the views of the community, that is, whether the new offense should include other types of penetrations, or whether it should cover adoptive parents. So the other area is a new offense called exposure. Now, this is mainly based on an English law, and this is different from the current offense of indecent exposure in the public. Now this is different because it focuses on the sexual offense. Now there is a target for exposure. That target person has not given the consent, and it's also for the purpose of sexual gratification. And then thirdly, there is a new offense of voyeurism. Now, whether you commit that with your eyes or with some equipment or instrument, provided it's a private act that's the object of voyeurism, and it's without consent, and if for a sexual purpose, then it's an offense. And this is also based on has reference to an English law. And then there's a reform of existing partiality, and we now going to so this is mainly to a different terminology. And then there is the new offense of sexual offense with a dead person. Now, this will be covered by a new offense. And then there are 3 proposals, mainly to deal with behavior where the sexual offense is not completed, but there is evidence to prove that there is an intention to commit a sexual offense. Now, there are inadequacies in current legislation, so we propose 3 reforms. One concerning the use of substance or drugs to engage in illicit sexual behavior, and this difference from the existing offense is not very great. It's mainly for clearer terminology, and it has reference to the English legislation. And then secondly, there is under the criminal ordinance, section 80B, there is assault on intended burglary, and this is too narrow. So we use the British English terminology. An offence, intention to commit offence that can lead to a sexual offence. So this is very near to the commission of the offence. And originally there is an offence of burglary with intent to commit rape, and we follow the English example. Now, if you enter a house without authority and if you intend to commit a sexual offence, then you are guilty. And finally, there are in existing legislation. Now, previously, our guiding principle is that a sexual offence shouldn't be based on discrimination against certain sexual preferences. So it's been determined that some offences are not valid for that reason, and so we have decided to recommend the removal of some associations where discrimination is involved. And then the bar association, Mr. Eric Kwok. The bar association does not have a stance that it wishes to review because we are undertaking a consultation exercise. Before long, we will collect the views and submit them to the Legal Reform Commission. So I will ask the deputation to speak. The first deputation, the concern against sexual violence against women, Ms. Wong. Now, concerning incest, we agree that it's a specific offense. Sexual offense by family member is quite common. For instance, by a father, the adoptive father, and other family members. Now, unlike England, we don't have a comprehensive set of laws to deal with these offences. So the offence of incest is used. Now, we also agree that this should cover offences committed by uncles and aunts. Now, sexual offences in our survey involve various categories of relatives, and we think that adoptive parents should be included. We think adoptive parents should not be included because one can choose to be married beyond the age of 20. We think that the offences should be sex neutral. Now, we think that the penetration should not just refer to the penile penetration. Now, non-penetration offences will not be in the same category now, and the new offence of exposure will provide greater protection, and we also agree that voyeurism should be made a criminal offense, but this may not cover the taking of photos under women's skirts. Now, there has been a large increase of over 15% in the past, in the years 2011 to 2016. And in England, there is a new offence of taking surreptive photos under women's skirts.
Thank you, Ms. Wong. Next, Mr. Tommy Chan, Rainbow Action Hong Kong. I'm happy to read the LRC's recommendation to fully decriminalize homosexual-related offences. In fact, there is a ruling 11 years ago that it is unconstitutional to have homosexual-related offences. It should be decriminalized. Consensual acts between two consenting homosexual adults should not be criminalized. However, this paper shows that there is a continuous oppression on sexual minorities. Of course, we need to deal with indecent assault and rape. However, I'm surprised to know that the Legislative Council doesn't know that there are already offences in Hong Kong regarding rape and indecent assault. We should not continue to commit the same mistake to criminalize any sexual act between two consenting adults. Otherwise, this is demonizing homosexuals and homosexual acts, and that the consultation paper continues to adopt the wrong concept. For example, on family relations, it is said that any sexual act between two consenting family members still poses a threat in the sense that there is coercion. The terminology incest will continue to be used, although it carries a negative connotation. The same mistake also can be shown in other areas such as exposure and other sexual offences. This is the most absurd recommendation from LRC. On the one hand, you're decriminalizing homosexual-related or homosexual sexual acts. On the other hand, you are criminalizing other forms of homosexual-related offences. In the summary, it is said that possession of GBH with intent to rape and so on and so forth. I'm stunned because among male homosexuals there is a use of GBH, but usually self-administered, or it is used on the consenting partner. It shows the LRC doesn't understand what happens in the community at all. Well, the consultation paper is embarrassing enough, but if we enact legislation wrongly, then the problem is even bigger. Exposure is one example. For sexual minorities, for the consultation paper, it is 1 angel versus 10 devils. Next, Ms. Cameron Kay from Hong Kong Women's Coalition on Equal Opportunities. please speak into the mic. Is it better now? Well, our coalition would like to talk about 2 new offences in the consultation paper, that is sexual exposure and voyeurism. We welcome the new offences because at the moment sexual exposure is not prosecuted clearly, but in the future there will be a clear offence for this kind of act, and the convict will carry a negative or will carry a conviction record. But we're concerned that there may not be adequate protection for children. According to the Scottish legislation, the one quoted by the LRC, there may be 3 offences relating depending on the age of victim. For example, children below the age of 13, between 13 and 16, and adults. In the second consultation paper, the LRC also mentioned the absolute responsibility of protecting children. This is an absolute liability offence. That is why for children we need to deter people from committing any unlawful act so to enhance protection on children. We welcome the other offence of voyeurism. At the moment there is nothing in the law to pinpoint any voyeuristic acts. Rather, we go about the situation by the offence of loitering, disrupting public order, etc. And the scope will also be expanded to cover private areas. However, as the previous speaker mentioned, for the new offence of voyeurism, it doesn't cover acts such as taking upskirt photos. According to police statistics, between 2016, the number of reports of upskirt photos reached 121 within the MTRCL area. At the moment, in the laws of Hong Kong, it is not clearly criminalized. It is just outrageous public morality or using the computer with dishonest intent. While we understand that the UK Parliament has recently moved a bill to include upskirt photos as part of the offence of voyeurism, and in fact there is a chapter specifically on the taking of upskirt photos. The bill is being examined by the UK Parliament, but there is strong support from the community and the UK government. We propose to the LRC that we can draw reference on this bill to include the taking of upskirt photos into the ordinance to make it clear that it is a criminal act. Otherwise, the problem will continue. All right, thank you. I'll open the floor for members to ask questions. Another deputation, sorry. We have chairperson of the Association of Women with Disabilities in Hong Kong, Ms. Young. Thank you. I'm going to make 3 suggestions on behalf of women with disabilities in Hong Kong. We'd like to expand the scope of incest to better protect the family network of the disabled because of the physical condition and financial circumstances. Very often the disabled would rely on the help of others in their daily lives, and most of them would be family members. So the scope of incest should be expanded to further protect the disabled. And as far as Hong Kong is concerned, many family members would abuse the trust of the disabled or believe that the disabled would be dependent on them, such that they would force or coerce the disabled into having sex, causing more harm to them. And therefore, we believe that any family member, regardless of whether it's really akin to the disabled, should be prosecuted if sex is involved, because it will destroy the family network and the dignity of the disabled. And it should be a gender-neutral offence, and the scope should be expanded to cover adoptive and foster parents. And we should also have gender perspective and review the definition of incest. Right now, it only covers vaginal intercourse. And we support the LRC's recommendation that it should be widened to cover any penetrative act with a penis into the mouth, vagina or anus. We believe that it should further be expanded to cover indecent assault, and the definition of indecent assault in section 122 of the Crimes Ordinance should be amended. Well, in fact, there is a case. A cleaner was accused of committing incest with a mildly handicapped daughter suffering from hearing impairment as well, and subsequently they lied in bed naked, and the cleaner put himself on top of the daughter. The daughter later on claimed that the father was very happy. In the end, the cleaner was acquitted of the offense of incest. We believe that although the act did not involve any kind of penetration, but any act involving sex should not happen between the father and the daughter, because this would give a wrong message for the daughter. And according to the UN International Convention, the UN confirms that disabled women and disabled girls are more vulnerable in terms of being subject to violence or abuse or harm, and there should be legislation and policies with children and women in focus. We hope the government will not ignore the special needs of the disabled women. Thank you. All right, open the floor for members. Each member will be given 4 minutes, questions and answers included. If we have more time for follow-up questions, then we'll do so. Let's start with Mr. Dennis Kwok. Thank you, Madam Chair. I believe that the focus of this paper is on homosexual-related offences, and I seek your enlightenment. Recommendation line in paragraph 117 of the paper. Can you elaborate on the thinking behind this recommendation?
用一少時間，我要揾。
Allow me some time to retrieve the page referred to. All right, we have sufficient time. It's in the executive summary. I think regarding this recommendation, the justification is clearly laid out. There is a guiding principle in reviewing sexual offences that there should not be discrimination against a person's sexual orientation. So we are proposing to replace or repeal the provisions in this regard because of their discriminatory nature, and that is why we're proposing to abolish these offences. Any follow-up question? I support your thinking, and I can envisage that there will be opposition from organizations. I hope that you will explain in greater detail to them. Mr. Ray Chen. I'd like to refer to voyeurism first. Different deputations mentioned the point about taking upskirt photos. Now, the LRC's recommendation on this occasion will not cover upskirt photos. But in other jurisdictions, upskirt photos is included as a part as the offense of voyeurism. At the moment, at best, we can prosecute someone with the offense of using computer with dishonest intent. But even if the person is convicted, there will not be a conviction record, and the person will not be on the list of the sexual conviction record check. Well, because it's not just about upskirt photos. Well, this can happen between two men. Let's say if a man is urinating in the toilet. Then another man takes a picture of the man relieving himself with a mobile phone. Again, the man will only be charged with the offence of loitering using computer with dishonest intent. And if you are minded to include upskirt photos as well, I do hope you will take note of the gender issue. And also for such conviction, would it be included in the SCRC, the conviction check? Well, let me respond to Mr. Ray Chan. First, on upskirt photo, it's also within the scope of our review. In our first consultation paper, we did make some recommendations and we received some feedback. And in this consultation paper, in which we proposed a new offence of voyeurism, and we have drawn reference from the English Act, Section 67, and indeed it doesn't cover the taking of upskirt photos in a public place, such as in a bus or train compartment, because the element is that the person, the location where the victim is, should allow her to reasonably expect privacy. And I understand that in UK they have the voyeurism No. 2 bill, a new bill that targets the taking of upskirt photos. But because of the time gap in our consultation paper, we did not refer to this bill because the consultation paper was published in May this year, and we also needed time for translation and other procedures. So we actually finalized the consultation paper way before that, but of course we will, in reviewing the consultation outcome, consider the new UK bill and also consider how we should deal with upskirt photos. Mr. Chan also gave another example. For example, using a mobile phone to take a picture of another person urinating. It's actually captured by the proposed offence of voyeurism, because if you take a picture of someone taking a shower or the private parts of a person with your mobile phone, this will be captured. What is not captured is the taking of upskirt photos in a public place like the MTR. How about the changing room of a boutique? If you take pictures stealthily, well, if at that place you don't expect anyone to see you and you can reasonably expect to have some privacy, then that will be captured. Because in a train compartment or bus compartment, you cannot really expect that people will not see you. What about the sexual conviction record check scheme? We proposed in the past an administrative measure. At the moment, it doesn't cover the proposed new offences. And after completing this exercise on sex offences themselves, we will then review other ancillary matters such as the sexual conviction record check scheme and consider whether such a conviction should be included.
釐清少少，我唔知有冇聽錯。
Now, I'd like to ask Ms. Wong. Now, you said that for step parents there might be marriage. So let me finish my question first. Now, and also how should one regard adoptive parents? And I'd like to ask Mr. Chen of Rainbow Action. Now, are you saying that as long as there is consent, then incest should not be a crime? First, Ms. Wong. we think that for step-parents, now they can marry if they are over 21. Now, if it's one's father, now even adopted parents are treated as parents. So now sometimes people divorce and get married, so one can have more than one stepfather. Now, we don't want to wait a long time, so we think we should deal with step-parents first. That is, they should be left out. And the English law doesn't just refer to upskirt photos. It also refers to beneath clothing, so it's gender neutral. I think it's worth discussing whether sexual act between adults should be legalized. Now, there are a brother and sister in Germany who gave birth to a child, and because there was incest, the brother was imprisoned twice. Now, it's a similar situation as criminalization of homosexuality. Now, the document says that incest harms the family, and this is a reason often cited against homosexuality. How about it between a minor and an adult? Yeah. I agree that Hong Kong has legislation to protect children. I'd like to reiterate that sexual assault and rape should be punished. Those should be prosecuted. I will let other members ask for the first round. Dr. Fernando Cheung. The third report of the LRC on sexual-related offences is finally released. So when will the administration respond and take action? We thank the deputations for expressing their views. We share many of their views. Basically, we represent the proposal by the group. Now, on upskirt photos, I will not repeat that. I have heard Mr. Cheung's response. That is, we will consider taking on board the English version. Now, on Rain Lily and other groups, they mentioned penile penetration may not cover other forms of serious sexual assault. So maybe the definition should be widened. And on adoptive parents, that should also be considered, because if there is already a formal adoption, then that would be actually the same as parrots. Now, I also agree that one shouldn't criminalize the sexual behavior between homosexuals. Now, that would draw a lot of criticism, and you should explain clearly. Now, regarding the 117 proposal, it's not easy to understand. So one should explain the background of decriminalizing homosexual behavior. No particular response. We are rather here to listen to people's views. Elizabeth Clark. Now, we have waited for better legal protection for sex offense victims. Now, we have asked Mr. Cheung questions on radio, etc. Now, after the laws are amended, will that resolve the issue regarding many of the complaints that we received? Now, deputations refer to voyeurism, not including upskirt photos. Now, also in public places like restaurants, people take photos of women's chests from a distance, and that's blatant taking of photos. And the voyeurism offense doesn't cover that. How do you deal with that? And there's this case this year. A girl under the age of 16 performed oral sex with a person, and that was not successfully prosecuted. So is it that our legislation would not protect such minors? Is there any law that can protect them? Mr. Cheung, let me try to respond. Two directions. Now, on voyeurism, I will not repeat certain points. We will review on so-called upskirt photos as long as is taking of photos without consent secretly. Now, on blatant taking of photos, now we will consider whether we should also consider factors, offenses that the public is concerned about. Now, our working group mainly focuses on sexual offenses. We will try to distinguish from them from offenses that relate to invasion of privacy, etc. Now, those offenses are not really sexual offenses that we focus on. So one element is that the offense is for sexual gratification. So we want to focus more on sexual offenses. And Mr. Kwok mentioned the case, Ms. Quack mentioned the case of the girl under age of 16. Now, to my understanding, the court was interpreting existing law. Now, if the defendant thought the girl was over 16, would that constitute an offense? Now, the CFA interprets that the existing offense does permit an offense of genuine belief that the girl is over 16. Now, on protection of children under 16, if we are going to reform the law, will we adopt the principle of absolute liability? Now, we will conduct a consultation, and we will also take into account the CFA decision, and we will come up with a recommendation. Second round, 3 minutes. First, Chen Chi-chun.
Thank you, Madam Chair. I'd like to ask Ms. Wong, representing the Association Concerning Sexual Violence Against Women. You just now mentioned that we should expand the scope of incest to prevent sexual assault on family members. However, the essence of incest is that even sexual acts between even two consenting adults would be prosecuted. For non-consenting members of the family, however, we already have other provisions in the law protecting the victim. So my feeling is that for consenting family members having sex, if the scope is widened, then I tend not to agree. I think that these are two different situations. But at the same time, I'd like to ask Rainbow Action. Your speech also relates to sexual acts with consent, that is between two consenting adults, and on bestiality, exposure, and necrophilia, the same applies. I don't quite understand what you mean. And also sexual acts between two consenting adults, but at the same time, a lot of sexual acts will be criminalized. Now, apart from this point about two consenting family adult members engaging in incest, what exactly do you mean? Let's start with Ms. Wong. Because we agree, because you think that, well, because in fact we believe it is sexual violence, even if it happens in the family between two consenting members. Because there is no alternative charge, sometimes the girl is charged with incest. Well, very often the offense is incest, not rape, but it is actually an error because the other side is pleading guilty to incest. For incest, the maximum sentence is 14 years. In 2017, there was a high court case. The father and the daughter engaged in consensual sexual acts. In the end, the father was imprisoned to 3 years, and the girl was also convicted and sentenced to a suspended sentence. But in fact, the nature of the offense should be rape. But because of other reasons, instead of charging the perpetrator with rape, he was charged with incest. And in fact, it's a dilemma for us as well. We considered whether or how it should be dealt with, and whether incest should be classified into consensual and non-consensual incest. Now, in UK, they have a rather good piece of legislation, but not in Hong Kong. So I need to ask whether the LRC would consider providing sentencing guide on such offences. In UK, we no longer have the common law reference, so I'm relying on local legislation and precedents, and I don't know how to resolve this issue either. In the end, I think that incest should be preserved to protect victims, but we also understand that for two consenting adults at the moment, both will be prosecuted. I'm afraid I can't answer this question. Who would I'll allow Mr. Chan to speak as well. Mr. Ray Chan just now asked you a question. For exposure, necrophilia, bestiality, of course, it could be done when consent is sought, but as for exposure, if it is done for the purpose of sexual gratification, or that there would be a threat posed to the other party, well, in a homosexual sauna place, and men would be naked, and if a man is in fear, then will the offense of exposure be charged? It's really common for cruising to happen in a gay scene, and I'm afraid this would be abused. So, all right, my turn, and I agree with the LRC's recommendations, including the offense of incest. My take is this. My heart is heavy, having heard the deputations. But I think in terms of protecting the mainstream views of Hong Kong people, if we abolish the offense of incest, I don't think it will be accepted by society. So I do feel that it should be retained. As to whether the scope of incest should be narrowed or widened, or whether we should include adoptive or foster parents as well, and step parents should be excluded, so on and so forth. On the whole, I agree with the LRC's recommendations. But on adoptive or foster parents, if there is a clear relationship, and I do understand there are cases in which eventually, after the child grows up, they enter into a romantic relationship. But this should happen after they have broken off the relationship as parent and child, because otherwise there could be abuse. Whether or not it is consensual, well, I think probably the persons involved might be quite confused. Perhaps the daughter might not want the father to be sent to prison, and might therefore say that it is consensual. But in the first place, there should have been a boundary that prevents such sexual acts to happen, breaching the trust of daughter for her father. So I question whether incest should be entirely not capturing step parent or foster or adoptive parents, and that's my comment. Now, on the point of whether we're decriminalizing homosexual acts, now on this point, I think if it is not related to the marriage institution, I, on the whole, support the LRC's recommendations, and that's my comment. I have nothing else to add. Second round, we have Dr. Elizabeth Quat. Thank you, Madam Chair. I'd like to respond to Mr. Zhang's question on on the minor, regarding the Women's Committee of the DAB, we believe it is important to protect a girl under the age of 16 from sexual assault. The perpetrator must carry absolute liability. Now, we're still in the consultation stage. We may have other comments to make, but I now have a question on another point. We believe that it would be more reasonable to change it to substance, from drugs to substance. And I hope that any substance that would render a person mentally incapable should be included as well. As for adoptive and foster parents, I am still thinking about it. My concern is when you adopt a child at a very young age, the parent can in fact groom, perhaps not control, but at least groom the child to engage in sexual acts when the child gets older. So I need to ponder on the issue a bit. Yes, Mr. Chairman would like to respond. Well, I've heard views expressed today, and may I first of all say that we keep all options open. I'm happy to take different views, but especially on the point of incest, we have heard divergent views, and perhaps I can explain the consideration we have made so that you can consider the subcommittee's view as well. Now, for the offense of incest, basically the scope doesn't distinguish consenting or non-consenting persons. Basically, if the definitions are met, the offense will have been committed, and the age limit can go beyond that of a minor. So we have considered some examples such as adoptive or foster parents. Now, if the child is below the age of 16, then the child is already protected under the existing legislation. By setting an age limit of 16, it is not discriminatory in nature because we are going to make it gender neutral. Well, any child below the age of 16, even if the consent has been given, will be a victim of this offense if you engage in a sexual act with her. And in fact, it's also included in the consultation paper. We don't know the outcome of the consultation yet. For a child between 16 and 18, if the other party is a figure of authority in the family, such as a parent, then whether the parent should be captured under this offense. And perhaps another category for those above the age of 18, then perhaps we need to consider for those who have consented in engaging in sex with a family member, whether it should be an offense. Perhaps one suggestion is to abolish incest altogether as long as there is consent, or that incest should be retained, at least for the part regarding parents. And also another suggestion, perhaps we should widen the scope of incest to include uncles and other family members who are not immediate family members. And that's also our recommendation. And there is also another suggestion that incest captures both sides of the family. Like Ms. Wong said, in reality, in a family, it's really difficult to tell whether there is consent. So there may be insufficient evidence to prove that the other party is not consenting, and as a result, we cannot charge the perpetrator with the offence of rape. On the other hand, even if there is clear evidence to show that it is consensual, we need to consider the impact on family structure, on society, and on whether, in the context of a family, sex should be allowed. Finally, Ms. Wong Xiaoyong also made another point. As far as I understand, if the prosecution has sufficient evidence to show that this is not consensual, then the defendant can be charged with rape. But in practice, perhaps because of insufficient evidence, etc., an alternative charge will be laid in unlawful sexual intercourse, rape, etc. But on the whole, I think the court will consider whether there is 100% consent, or whether it's voluntary, or even if it is voluntary, whether there is an abuse of authority, and this would affect the court's sentencing. And as far as common law in Hong Kong is concerned, we seldom see sentencing guidelines for judges, so it's really up to judges.
We would be glad to listen to views on whether there should be clear guidelines on sentencing for certain offences. So I think we will end the discussion at this time. We thank you for sitting through till 7:16, and this is the last meeting of the AJLS panel, and we are very appreciative that you have been sitting through these meetings. We can take a break for the recess. Any further comments, you can submit them to the LRC. We wish you a happy summer recess. Thank you.